next case is Boyette versus Brad Parrish, Newman Heating and Air Conditioning. Is the appellant ready to proceed?
Yes, Your
Yeah,
Honor.
wait a minute.
Good afternoon. My name is Julie Fine, and along with co-counsel Jack Fine, we represent appellant Tammy Boyette. I would like to reserve 5 minutes for rebuttal. May it please the court. Appellant is asking this court to reverse the trial court order denying plaintiff's motion for new trial and asking this court to remand for a new trial as there were numerous errors that occurred which were both harmful and which accumulated over the course of the trial, denying the appellant the right to a fair trial. Specifically, the errors included: 1, it was reversible error to allow character evidence that the appellee had never had an accident and never had a ticket, contrary to Florida Evidence Code 90.404. 2, once that was admitted, it was error to deny appellant the right to impeach or the ability to impeach the credibility of Ed Newmans, who made misleading statements regarding appellee's driving. And 3, in closing argument, the errors were compounded as appellee's counsel continued to emphasize the improperly admitted propensity evidence. And 4, improper closing arguments. Regarding the first issue, the improperly admitted character evidence of the defendant's driving, this court is to review this under abuse of discretion, but a judge's discretion is limited by the rules of evidence, and here we have a rule of evidence right on point.
Let's talk about that. That's fine. You have a question that starts out, do you think, which to me is akin to, do you believe, asking Mr. Newmans for his opinion. What do you do with the appellee's argument that the door was open to the very thing that happened? When you ask the principally affected party an open-ended question, do you think, do you believe, do you have an opinion, you get exactly what you asked for. How do you respond to that?
Your Honor, this was direct examination, so it wasn't it was an adverse witness, but that's why it wasn't a leading question. But to answer your question about specifically the content of what was asked, it was not regarding the driving history of Brad Parrish in any way. The question was, do you think the combination of talking on the phone for 5 minutes can contribute to not knowing how fast you're going, can reduce your focus? In other words, do you think those things can reduce your focus?
Well, let's deal with that. So let's cede for a moment that the answer was beyond the question. And then Mr. Fine says, I move to strike the answer. He doesn't give the reason, but I presume he meant I moved to strike it because it was not responsive to the question. But we're left with that. There is no request for a sidebar. There was no request for a mistrial. There was no request of the court that this is so inflammatory, this is so harmful, we can't possibly rectify this. We need a curative instruction to this jury. Again, I believe, and we're going to hear from him in a minute, the other side would say, well, you didn't give the court an opportunity to deal with this problem. What's your response to that?
Your Honor, the response by Mr. Fine, he immediately objects. Okay, he says, I'm going to ask for that testimony to be struck, Your Honor. And the court interjects response. As soon as he says that, he doesn't even have an opportunity to respond, but I would also kind of bring the court back to motions in limine, which were argued, I believe, earlier in that day, regarding this issue about improper tickets, or regarding the driving record of Mr. Brad Parrish. There was a motion in limine filed by plaintiff that requested that this not be brought up, that there were concerns that they might try to bring up reputation of how great they are, how this is a local business, they have great reputations, how they have great driving records. So this had already been discussed in motions in limine, and so I believe the court, especially knowing that we had a motion in limine on this, was aware of how this was improper. And then she asks for a response, and she overrules the motion to strike. And because she overrules the motion to strike, this issue is preserved. There's no need to ask for a mistrial when a judge overrules counsel because the judge has deemed it not improper, and
Well,
there's no way to actually ask for a mistrial at that point.
Well, but perhaps not, perhaps so. What prevented, and I know being a trial lawyer is a very difficult task. I did it for a long time. It's hard work, and one never knows what's coming out of those gates until it comes out of the gates. And I again will grant Mr. Khan or Mr. Fine didn't know that Mr. Newmans was going to say what he was going to say until he said it, because it was not responsive to the question. But as to communicating to this trial court, we've got a problem here. I mean, we have something that we're really concerned about. This was brought up in a motion in limine. There was a concession apparently by the defense counsel that this was something they had conceded. Why wouldn't there be a responsibility to at least ask the court for a curative instruction, even at a break, to say, Judge, you need to tell this jury to disregard this? And why would that not be something for us to consider when you're saying this whole verdict needs to be set aside?
Yes, Your Honor. The issue here is that the judge didn't sustain the objection. If the judge had sustained the objection, then it would be the responsibility of the plaintiff or whoever it may be to ask for a curative instruction to go a step further. But when the judge overrules your objection to something, you don't have the opportunity to ask for a curative instruction. At that point, the judge has deemed that it's appropriate. It should be in front of the jury. And additionally, this issue was brought up again when in cross-examination, the defense comes back and starts asking questions about the defendant, the appellee's driving record, and how he's never had an accident before and how they wouldn't hire bad drivers. And there was a very specific objection at that point by plaintiff's counsel where he says, Your Honor, this is specifically, we believe it's irrelevant and prejudicial. And she overrules that objection as well. And so at that point, clearly we have a situation where it's preserved. This issue has been preserved, and Murphy does not come into play when there's an overruled objection. And I would suggest that in the first instance, the objection was overruled as well.
How, and maybe this is a big picture question, how can we divine from this that it was so prejudicial, that it was so inflammatory, that it affected this verdict? I mean, what is our algorithm? What is our formulaic to go about that?
Yes, Your Honor. In this situation where we have errors of the trial court, when there's admitting evidence or excluding evidence, the burden under Special v. West Boca, which the Florida Supreme Court has made clear, is upon, unless the beneficiary of the error proves there's no reasonable possibility that the error contributed to the verdict, the error is considered harmful. And so determining whether or not this is harmful is important here. It is a burden on the appellee at this point as the beneficiary of the error. However, it's very clear in this case that there was harm. We have a 5% liability. 5% is all that was awarded or was given to the defendant, the one who has this great driving record, who's never had a ticket and never had an accident. And that was the key issue. That was the one thing that this trial was really about. It was truly a trial about liability. Who is at fault here? So,
Was not the trial about the legal cause? And could not the jury have found that Mr. White was even the sole cause of setting in motion this cascade of events that led to the unfortunate circumstance where your client suffered these catastrophic injuries?
So, Your Honor, the issue of causation, I think, was actually not something really contested. The defense never contested that the injuries occurred, that 100% of the injuries occurred from the second crash. So that the crash between the appellee and the plaintiff was clearly what caused her injuries. And in this situation, we have someone speeding 10 miles per hour over the limit. All of the injuries are from this second crash. We have someone who's talking on the cell phone. We have someone who's literally balancing that cell phone on their shoulder. He never even sees a vehicle that we have testimony, there's evidence that is stopped in the middle of the roadway. He never even sees it before he hits it. And so the issue at trial was whether or not he was distracted. And still the jury comes back with a 5% liability. And clearly the testimony about he's never had an accident, he's never had a ticket, did harm the plaintiff, but it's not our burden to prove that. But I believe it's pretty clear as saying that this individual is a great driver, and
But I think my colleague's question may go more toward, I appreciate your response, but the evidence was the 17-year-old uninsured driver hit your client first, knocked her into the intersection, and there were so many seconds before the defendant, the appellee here, hit your client. So how good a driver he may have been, how particularly relevant was that, or important in terms of the, point of impact, if you will?
I believe that it was extremely important because the main issue was fault. Who was at fault here? And if you have someone's credibility bolstered by the fact that they're a great driver who's never done anything wrong.
Well, I mean, my question goes more towards, you don't dispute the 17-year-old driver was at fault.
No, Your Honor. Plaintiff appellant at trial said there was 20% liability on that individual, and said that, but the majority of the fault was on the defendant driver, because we have, in this fact scenario, we also have another vehicle who's driving on the same road as the appellee and is able to come to a complete stop. And he's in front of this driver. He has less time to stop, and he's still able to stop. And so had this driver, our theory of the case was that he was distracted, he was not paying attention. And so the evidence about him being a great driver who, bolstering his credibility, makes it seem as if it goes against our test, it goes against our evidence, and it's not even true. We weren't even allowed to impeach it. He has had accidents, he has had tickets, and it's not supposed to be about his prior experience. It's supposed to be what was going on at that time. Was he distracted? And so it was clearly harmful because it brought in evidence of propensity, which is not allowed by Florida statutes or case law. And if I could, I would like to reserve the remainder of my time for rebuttal. Thank you.
Thank you, Your Honors. May it please the Court. I'm Michael Korn of Korn & Zemer, Jacksonville. I represent the appellees in this case. This case, as many contested liability cases, involved really a battle of experts about causation. The causation was this an avoidable collision? Counsel alluded to some of the facts. She finally got to one of the important facts towards the end, which was the obscuring of Mr. Parrish's view of the intersection as he approached it by the slow-moving RV towing a car that blocked, according to Mr. Ketchum, the defense expert, that blocked Mr. Parrish's view. And also, she talked very briefly, but I think we need to go back to the issue of reaction time. And this all goes back to the harmfulness or lack of harm of the points that counsel now tries to persuade this court requires reversal. All of the experts, including Dr. Boehm, the plaintiff's expert, the biomechanical fellow, as well as Mr. Hoy, all noted there is a brain function about the time that a person perceives a danger and has the ability to react. The only data in this case indicates that time was about 2.5 seconds from the point that the person first sees the hazard, the unexpected hazard, and the ability to react. Much was made at trial of the data that was drawn down from the black box in our client's vehicle, which was, by the way, the only data that was drawn down. None of the other vehicles, Mr. White's vehicle, the Lexus that rammed the plaintiff through the intersection at South Main Street into the Williston Road intersection, that data was unavailable. There was no data available from the Honda vehicle that the plaintiff was operating. And there was no data drawn from the RV. The RV's position, of course, was a disputed issue at trial. in part because, as Mr. Ketchum testified during the defense case, there were no markers to show where the RV was, because he was never in a collision, and there was no point where anybody could say exactly where he was vis-a-vis the intersection. So why is this all important? It's important because this was a contested issue of liability, and that the Fabre defendant, Mr. White, was, according to the defense theory of the case, the precipitating factor of this collision. From the very beginning of the case, the defense noted this was a case of wrong place and wrong time for both parties.
Well, let me go back to the argument that was made
Yes, sir.
a minute ago, in line with what you just said. 2.5 seconds seems to be the expert testimony in this case. Doesn't that enhance the importance of being aware of your circumstances, your sensorium, what's going around you? And would that not make this more relevant, that his credibility as far as his distraction at the time of the collision, wouldn't that be enhanced by virtue of that compressed amount of time for him to make a decision?
Well, to the extent that, if Your Honor is suggesting that somehow makes the illusion that counsel refers to somehow more harmful, I would respectfully disagree.
I think that's their argument.
Yeah,
I believe.
That was my sense of it as well. And in this instance, even counsel acknowledged at one of the post-verdict motion hearings, it was not the most artful question that was ever asked. And Judge Jay, you observed at the beginning of your questioning to counsel the idea that when you ask an open-ended question about opinion, would this have created some kind of a deficit in focus? Not exactly the words, but I think that was the concept. And Mr. Newmans testified, and he didn't. And it's important to say also, he never said that he never had a ticket. The exact testimony was, he's been working for me for 10 years, and in that time, he's never had a ticket with my vehicles. There was no discussion about what his driving history was in that question, other than as it relates to the scope of his employment. Later on, there's an attempt when trying to publish portions of Mr. Parrish's deposition, which they chose to use in lieu of having him testify live. They wanted to try to impeach him. Counsel alluded to that at the end of her argument. They wanted to impeach him with some unknown document, which was never proffered, never discussed, and the trial judge appropriately said, look, you can't get into that. We don't even know what it is. And this court certainly can't determine from this record where the document was A, never proffered, B, the supposed contents were never disclosed. There was no attempt to voir dire so that the defense could even determine whether it was reliable or not. So
I'm sorry to interrupt.
I'm sorry.
Gordon, I want to go back to the do you think question.
Sure.
You would agree, would you not, that his answer, that ultimate answer about never had a ticket, never had an accident, was not responsive to the question asked? You would agree with that, would you not?
I would suggest that it was, for a layperson, his attempt to answer the question that was being asked. The trial court made a determination that it was not subject to being stricken. And contrary to counsel's position, whether it was a correct ruling or not, I would suggest that the appropriate and required event that should have taken place then was for counsel to say, Your Honor, we approach. Have a sidebar conference. Say, Your Honor, maybe let me explain a little bit more why I believe that's inappropriate. And if the issue was of such import, such significance, this, remember, is the third live witness of this multi-day trial, then they should have asked for a mistrial. They should have asked for a curative instruction. They didn't. Even at the post-verdict motion hearing, counsel conceded, I didn't ask for a curative, I didn't ask for mistrial, and I should have.
What do you do with the argument we just heard? There was a motion in limine to get rid of this type of testimony, and this spills into the trial. It sounds like, from all accounts, it had been conceded. What do we do with that? Isn't that a bad event?
Respectfully, let me suggest that I don't believe this record can establish this concession, because if you go to the actual colloquy that's going on, first, there's no order entered by the court. The court never entered an order. The court even on the record never made any mention. What it was, and I don't remember whether it was Mr. Fine or Ms. Fine, were basically talking to each other. And one said, oh, and we need to bring up this issue about driving history, and one said X, and the next one said they've agreed to that, and they moved on. There was no reference in this record as to whether counsel was even in the room. They're getting ready for a trial. There were some unusual circumstances surrounding how the trial was being conducted. So I don't think Your Honors can take the record as it sits here and say with any conclusive certainty that that was in violation of some order in limine, because there was no order entered. Even so, Your Honor, even if there had been an order in limine entered, all the more reason why a curative instruction then should have been requested. They should have gone to sidebar. They should have said, Your Honor, this was an issue we discussed before. You should instruct the jury not to consider this. And if they believed that it was of such grave import, they should have asked for a mistrial. And they didn't.
Was there ever a request for mistrial at any point during this trial from the plaintiff or the...
I know, Your Honor, that there was a request for curative instructions at one point where defense counsel had, when they were talking about the life care plan, and there was some issue with the life care plan or about how much certain things might cost, and there was an issue about whether the potential repeal of the Affordable Care Act might have an impact on that. And there was an objection. The court sustained the objection, and a curative instruction was sought there. So it's not like counsel doesn't know how to ask for a curative instruction. It was done during the trial. As to whether there was a specific mistrial request, I don't believe that there was one. I will refer back to the record and see if I can find something. But there were at least the one, and there may have been one other time where a curative was requested. The one I remember most vividly, Your Honor, was the one about the Affordable Care Act issue. But there was no request for mistrial. And, what we have here is a situation where counsel just is understandably distraught because the jury, having heard the expert testimony from plaintiff's experts and the expert testimony from the defendant's experts, found that first, unlike what counsel said, there was testimony that that vehicle, the plaintiff's vehicle that was rear-ended, was in fact still in motion at the time our client collided. Now, that's a disputed issue of fact. That's what juries do every day. They hear testimony from experts. They hear testimony from lay witnesses. They use their common sense, and they align the facts. So in this instance, for them to say that there was no reason, no possible basis under the special theory, special request BOCA, there was no way this verdict could have been obtained but for these alleged errors, is just not correct in our view, because there was ample testimony that but for the collision that propels Ms. Boyette through the intersection, none of this would have happened. So when they say that the damages that Ms. Boyette suffered in the collision in the intersection were caused solely by the collision with the Chevy Silverado, well, that's true. But you're mixing apples and oranges here.
Well, and it was undisputed in this record that Mr. White and Mr. Parrish were joint tortfeasors in this circumstance, so 768-81 would apply. I mean, that was an undisputed fact that they together caused this accident.
81 wasn't ever explicitly referred to in the pleadings or in the record, but
I saw it in the answer. But
no, the point I'm getting at is in the complaint, Mr. White didn't exist. It was just, who? No. Didn't have it. Now, they did agree not to make mention of the fact that Mr. White had not been sued as part of the original complaint.
I guess my point, Mr. Corn, as you well know, if you don't have a Stewart versus Hertz situation,
right,
and you have joint tortfeasors, so it was undisputed, I think, in this record that you had purported joint tortfeasors, the Parrish vehicle, the White vehicle, and to the extent the plaintiff may have had negligence. It was all, I know it was two separate events, but it was one act together that the jury was to evaluate. And
they evaluated it by the 95-5-0 allocation. And to that extent, Your Honor, if I might, I want to talk a little bit about the zero allocation to the plaintiff.
Let me just finish.
Yes, sir. I'm sorry.
Clear in my mind. But you don't have a situation where you have a Stewart versus Hertz where that initiating event, the White event, was separate and apart from the Parrish event, which we sometimes see in products cases and med mal cases. Correct?
Well, it was clearly one one event. I mean, and what the defense theory was, and even the plaintiff's experts confirmed this. Their engineers confirmed that had it not been for Mr. White rear-ending Ms. Boyette at anywhere from 20 some approximate mile-an-hour speed, she would never have been propelled into the intersection.
Well, and my point in even asking that question is there was some intimation on the appellant's initial argument that Dr. Bayman, I read his testimony, said that that was the initiator of her ejectment, meaning Mr. Parrish's vehicle hitting her, but all of that was together. It was a confluence of events under 76881.
I think that's a fair assessment. So if I just draw briefly on the zero. The counsel, in both the briefs and in their argument, would have this court believe that this jury somehow got bamboozled into thinking that Mr. Parrish was absolutely scot-free, and I would suggest that's not the case if you look at the actual components of the verdict. First, the zero liability, despite the fact that she wasn't wearing a seatbelt. Dr. Bain suggested that she didn't get ejected from the vehicle left her, which is kind of an interesting way of phrasing that. I hadn't heard that before. There was also some at least disputed question about whether she could have in fact taken evasive action if she was stopped. They can't have it both ways. Either she is being propelled and the vehicle is moving at the time of the collision, which was suggested to be the case by Mr. Ketchum's crash theory and the momentum analysis that he testified to. He said that the deployment of the airbag would not have occurred if she had been stationary. And with respect, so that's on the liability side. Let's talk about the damages for a minute as to whether this jury was somehow bamboozled or prejudiced, which brings up the whole four-pronged test of Murphy. Here, the jury awarded her virtually all of the medicals that she asked for, virtually all of the lost wage that she asked for. They asked for a large number with respect to pain and suffering, but they should get $150,000 in past pain and suffering and $1 million in future pain and suffering. Now, we can argue about whether that was a small award, a big award, but that's what the juries do every day. They assess damages. And there's no, as we all know, the case law says there's no rule, there's no slide rule that says what it ought to be. There's nothing that you can point to say that this jury didn't do a good job with the facts that they had, dispassionately determined the damages that this lady suffered, and then just as dispassionately assessed how the liability should be apportioned between the Fabre defendant and my client. For these reasons, and the cumulative issue, I would respectfully suggest, I think it's the old 0 plus 0 plus 0 still equals 0. And so if there's no harmful error that's occurred in any of the other three issues, the fact that I raised three issues before doesn't make them any greater or any more persuasive. My time has expired. I appreciate the court's attention and your questions. I would respectfully suggest that you affirm this judgment. Thank you, Your Honors.
Please, court, just to focus on some of those issues that opposing counsel has brought up. The amount of evidence that is in this case on one side or the other is not the focus that this court needs to be focused on. Within Special v. West Boca, this Florida Supreme Court has specifically said that the harmless error test is not a sufficiency of the evidence, a correct result, a not clearly wrong, a substantial evidence, a more probable than not, a clear and convincing, or even an overwhelming evidence test. It should be focused on the error itself. And in this situation, we have credibility of a witness being a huge factor in this case. We have one witness, the appellee, the driver, saying he never saw the vehicle. It came out of nowhere. And that's their position, that it came out of nowhere. So whether or not he is a focused driver, he's a good driver, he pays attention, he doesn't get in accidents, he doesn't have tickets, is very important to this case. Whether or not he's a credible person when he is driving, and whether or not he's ever had this happen to him before, that's clearly going to affect the jury in their consideration. It also goes to sympathy, which is improper, which was brought in closing argument again. And it wasn't an isolated incident. Sometimes we have these cases where they say, well, it was an isolated incident. But that we know this was important because another indicator was that defense counsel went in again on direct. He knew that or on cross-examination, he knew that this was a key factor. So he brings it up again, asking, oh, so he's never had an accident with this car before. He's never had, you wouldn't hire people with bad driving records because he knows that that has a prejudicial effect, and he capitalized on it. He emphasized it, and he brought it up again in closing argument. And so this court needs to be focused on whether or not I think the appellee has conceded that there was, I don't know if they have conceded there's an error, but if this court finds that there's an error, the focus needs to be on what the harm is, and the harm is very clear in this case that propensity evidence was used. It was a very, very large part of this case. And additionally, I know that Your Honor has suggested there should have been a curative instruction, and counsel said, yes, they should have gone up, they should have asked for this, they should have asked for a mistrial. And I suggest that appellee is asking this court to create new law, requiring a curative instruction after an overruled objection. And that is just not the law at this point. And in fact, we did ask for a sidebar after this objection, after we found the impeachable evidence, to go up and say, Your Honor, this is the issue, this is important. And this, as well as all of our arguments within the closing argument section, is the cumulative effect of all of the arguments combined prejudice this plaintiff, and we're asking for a new trial on that basis. So thank you.
Thank you. Thank you both for your arguments. The court will be in short recess. Reconstitute the panel.